Welcome to this podcast. Before we start, please remember to subscribe to this YouTube channel by simply clicking on the subscribe button below this video. This will ensure that you always get our new and updated podcasts on transfer pricing. Okay, let's jump right in. In today's podcast, we will be summarizing a recent transfer pricing case. Let's take a look at Prime Plastichem Nigeria Limited v Federal Inland Revenue Service, TAT-LZ-CIT-015-2017. This case discussion merely focuses on the aspect of the burden of proof. The facts of the case, briefly summarized, were as follows. The taxpayer, in 2013, adopted the comparable uncontrolled price method, CUP, in determining whether the pricing of its transactions with a related company were at arm's length. Due to a lack of comparable, the taxpayer, in 2014 adopted the transactional net margin method, TNMM. When the FIRS reviewed the taxpayer's transfer pricing documentation, it concluded that the company's comparable data for 2013 did not meet the comparability requirements of the TP regulations and that the taxpayer had therefore wrongly applied the CUP method in determining its arm's length price for 2013. The taxpayer argued that the FIRS did not discharge the onus of proving transfer mispricing or absence of arm's length principle. The taxpayer maintained that he is under an obligation by paragraph 610 of the transfer pricing regulation to provide documentations to show that the conditions of the controlled transactions are consistent with the arm's length principle as provided in the transfer pricing regulation. The taxpayer argued that they have discharged this obligation because all the TP documentations were duly filed, all queries were promptly responded to, and in fact additional documents were provided in the discharge of this obligation. The FIRS, on the other hand, argued that the taxpayer failed to discharge the legal burden of proof required to establish its claims and reliefs against the FIRS in this appeal. The FIRS maintained that the documentation provided by the taxpayer is not sufficient to discharge the burden placed on them by the provisions of sections 131 and 132 of the Evidence Act 2011. The FIRS further argued that the taxpayer had failed to demonstrate that the CUP method was the most appropriate method to use in this instant case, thereby failing to satisfy the conditions prescribed by the transfer pricing regulations. The FIRS went further to state that the taxpayer, on its own, identified this problem of lack of reliable data and changed its methodology from CUP used in 2014 assessment year to TNMM in the 2015 assessment year. That since the taxpayer was unable to provide to the FIRS reliable information that satisfactorily explained its use of CUP method for 2014 assessment year, the FIRS has no choice but to jettison the CUP method used and adopt the TNMM for the 2014 and 2015 assessment years respectively. The FIRS justified its rejection of CUP method because its decision was in accordance with the TPR and also in consonance with the provisions canvassed by the OECD in its transfer pricing guidelines. This fact is alluded to by the testimony of the taxpayer's witness who admitted in the course of his evidence before the tribunal that the use of CUP methods requires reliable data. The tribunal determined that the taxpayer did not provide sufficient information to the FIRS to justify the taxpayer's adoption of the CUP method as the most appropriate method. Thank you for listening to this podcast. Remember, click on the subscribe button below this video to always get our new and updated transfer pricing podcasts. Have a great day.